Jefferson County Court at Law number 2 is now in session. The court is in session with the court's trial docket on today's date of September 19, 2023. The court has 3 cases on its trial docket. We have cause number M329124, cases style of state of Texas versus Tremaine Lamarcus Kennedy. Mr. Bailey, would you please call the name of Tremaine Kennedy at the courthouse door? Okay, Tremaine Kennedy's name was just called at the courthouse door. Tremaine Kennedy did not answer. Tremaine Kennedy was scheduled to be in court today at 1:30 p.m. The time now is 1:48 p.m. on today's date. Tremaine Kennedy is not in the courtroom. Tremaine Kennedy's attorney Bruce Cobb, is also not in the courtroom. State, you have a motion?
Yes, state moves for bond forfeiture.
That motion will be granted. Tremaine Kennedy's bond will be forfeited and a warrant shall be issued for his arrest in cause number M329124. Next case is cause number M329988, case is style of state of Texas versus Daniel E. Domina Rivera. Mr. Rivera is present in court with his attorney, Mr. Langston Adams. And Mr. Adams, on yesterday, you had announced ready, is that correct?
Yes, Your Honor, and the state did as well.
Okay, state also is present with Ms. Okay. With is Erica Porter. State, are you ready?
Your Honor, the state has a motion for continuance on file. We need to approach responding.
Okay, y'all can approach the bench. Mr.
I think I'm need.
Adams, Mr. Adams, did you get a copy?
Yeah, I got it.
Okay, we need to turn that, hold on a minute. Okay, now, Mrs. Porter, I have before me a copy of the state's first motion for continuance. That motion was for continuance was filed on yesterday.
Correct.
At 5 p.m. according to the file stamp. Mr. Adams, did you receive a copy of this motion?
Yes, Your Honor, and I would like you to take judicial notice of what you just said, which is it's technically she filed it at the end of the business day, 5 p.m. So I wouldn't have been technically served till today on. So my objection to it is it's untimely. She filed it, you just said it was at 5:02.
That's what I'm looking at file stamp. Did you get a copy of the motion?
Yes, I did get a copy. I printed it off, and my objection is untimely.
Okay.
I
Okay,
have a response to that objection.
okay, you may.
The state was just notified at 4:49, right before I filed it, about 4:47, of the officer's unavailability. And so I drafted it real quick, changed the names and filed it as soon as I received it. So I filed it as soon as I timed it.
Yes, can I respond, Your Honor?
Yes.
She has 2 problems with that response. If you look at the body of her motion itself, it works against her. And in the body, she says that she sent a trial letter in August of 16. If the witness was unavailable for today and a letter was sent in August, then that witness would have had a duty to let her know before 4:49 on yesterday, after she had announced ready for trial. So if I would assume that that witness would have been talking to or spoken to before 4:49. So again, it's absolutely untimely. Also, I would like to bring to the court's attention that had the state said they needed a continuance before announcing ready, typically I agree to that. Her partner in this courtroom, Kobe Hoffbauer, I had a case that was a 2021 case just as well, 2021. Hoffbauer said, hey, I have a conference to go to. He did that before announcing ready. Linda is in the courtroom right here. She can tell you. She called me and said, well, hey, it's our practice. Do you agree to this? What I told you, Brenda, I said, I agree. He got a conference. That true or false? But that's true. But in this particular case, the state said to you in open court, we are ready for trial. So once you make that announcement that you're ready, that ship has passed. So in terms of her saying that, hey, give me a continuance, then there is no due diligence whatsoever. Lastly, but not least, in the prior case that you just mentioned, the state asked that a warrant be issued for the guy's arrest who did not show, right? That's what they just asked for, right, Judge? The guy who's not here court now, the first case, they asked that a warrant be issued upon property. That's what they asked for, right? Judge, I actually look at the court's file. If you look at the court's file, you will see that Aaron Taylor, who they asked for a continuance on, she said she sent a letter August the 16th, 2023. The problem with that is I served him with a subpoena in June of 2023, and that's in the court's file. So if they're gonna ask for a continuance, then I actually issue a bench warrant for him right now and put him in jail. Aaron Taylor, who is, I got a copy of the subpoena right here. Look at the date I issued it. So I issued him a subpoena to show the court. So there is no good reason when he got my subpoena in June, he should have told them, said something about having a conference. So at the end of the day, I have the benefit of my subpoena. Also in their motion, they said they sent a letter. A letter is not the way you get a person to come to court. You get a person to come to court by way of subpoena.
Hold on a minute.
That wasn't done.
Hold on a minute. Hold on a minute. He might be a juror. No, the guy, there's a guy back there he's talking to.
And just notice that the motion in and of itself is insufficient because she doesn't tell you why Mr. Taylor isn't here. She does not put in this motion, hey, Mr. Taylor is dying on his deathbed. He's in the hospital. He can't be in here. She offers you no. So on its face, it's insufficient. 1, 2, you don't have the proper notice. And then even 3, it's not even notarized. And look, if you look at the statute, it has to be sworn to. I don't see an affidavit attached to this as well. So on its face is deficient. 2, notice it was not properly given. 3, I subpoenaed that officer. That officer is under subpoena to be here today. And then 4, she didn't even put why he's not here. I would ask her to tell the court right now, why is it that he's not here? Please explain to the court. He got a letter according to her in August. He got a subpoena from me in June. I actually look at the court's file. I sent him a subpoena. I got a copy of the subpoena. So in spite of the subpoena, in spite of her letter, he's not here. So I guess the state is asking you to hold her police officer in contempt of court. That's what she's asking you to do. Because if she's saying that in her letter, she sent him a letter on the 16th, and I sent him a subpoena, she's arguing that you hold him in contempt of court. So I would actually do that.
If the defense, I didn't ask for that, but if the defense is finished arguing, I would like to.
Okay, you may respond.
Okay, I call your attention to Texas Code of Criminal Procedure, Article 29.04. First motion of state. This is our first motion for continuance. And in that article, it says nothing about stating why he's not supposed to be there, but I'll gladly elaborate and tell you why he's not here. He's not here simply because he's in training. He's in Dallas. And it would be great if all the officers would let me know a month ahead of time, but they don't do that. Some of them don't let me know until I'm asking someone in my office, like James, to try to find them because they're not responding to me via text or email. So we were able to finally get a response. He had completed training for the day. It was almost 5 o'clock, and that's when I filed the motion for continuance. It's sufficient because it's red letter. Article 29.04 is our first motion. He's a material witness. He needs to be here, and he's unable to be here. And I know where he's at. He's in training in Dallas.
Quick response. I would objectively be able to prove to you that this is not your first motion for continuance. I can objectively prove that. And then secondly, again, she only proves my point. If she's saying that he's in a training in Dallas, well, you don't sign up for a training a week before training. He got my subpoena in June. He got a letter from them in August. And for her to announce ready to you at 9 a.m., but then file a motion at 5:02 p.m. at the end of the day, there is no good cause for him not to be here. When he got my subpoena in June, when he got her letter in August, he should have rescheduled that particular training. He didn't. So at the end of the day, you can do one thing. You can issue a writ of attachment for him right now, and you can hold him in contempt of court, because what she's basically done is this. I sent him a subpoena. She sent him a letter. So what can he say? I didn't have notice about the trial hearing. The trial setting, and I went to my conference in Dallas anyway. She's giving you more ammunition to put him in jail. The state is giving you ammunition to put their police officer in jail based upon what she just said. Now, so I would say again, and like I said, I got the subpoena. You can look in the court's file. Here it is right here. I got a copy of it. I'd be happy to show them a copy of it. It was dated June 19th. It's in the file. I got it.
Okay, I got it up here.
He was served. So at the end of the day, there is no legal reason to grant this continuance. There is not a legal reason to do so. They announced ready. They're ready, should be ready. And like I said, I gave you an example. When Kobe Hoffroy came to me and said he had a training before he announced ready, I said, I agree with it. Okay, reset the case. But yesterday, they said they were ready. So let their ready mean ready.
Do you need me to?
Do you have a response?
Only that sometimes situations occur. If that his theory was true, you're saying you'll be ready if someone died or your child died or your family member died, but you still gotta be ready because you announced ready. That theory is flawed. I had no idea this officer was not going to be here. Absolutely no idea, because sometimes they don't respond quickly. Sometimes they do. I had to round him up. And as soon as I found out he was not available, I filed my motion. So ready means ready at that time. Ready does not mean ready on the date simply because something happened. If he were here, we would definitely be ready to move forward. We're not trying to stall. The evidence is sufficient enough. So we're not stalling. However, I need him here. He's a material witness. I filed under 29.04. It goes right back to Texas Code of Criminal Procedure. We are entitled to it, and that's why we're requesting it from you, Your Honor.
Okay. Judge, if you keep notes of all our settings. Let me stand up. You keep notes of all our settings. We're now in September of 2023. We're in September of 2023. Look at your docket sheet. Look at the reasons why the case has been reset all these times from 2021 to now 2023. And you will see they all haven't been reset because of defense. Just look at your hand. Every day I see you in the courtroom, you make notes of why a case has been reset. So when she says that this is the state's first continuance, I say, look at your notes. Your notes show that this is not the state's first continuance in the particular case. Just look at your notes. Look at every time that we've come in the courtroom, why the case is reset. Look at your own notes and you tell me what you see. At the end of the day, here's what we have. We cannot have a situation where the state of Texas says, we're ready, but in fact, at the very last minute, we're gonna try to hurry and get together real fast, and then we realize we're not ready, and then at the end of the day, we're gonna file a motion for continuance. We cannot allow that precedent to be set. She said that she was ready, and her motion argues against her point. One is not specific, is not notarized, is not sworn to, and particularly what she said, if the guy is at a conference, we know one thing, he's not dying, he's not in a hospital, he's not ill. He chose to go to a conference in spite of the fact that he was served with a subpoena and was sent their letter. And at least if I believe her, she didn't know about this until 4 o'clock yesterday. So that means in spite my subpoena, in spite her letter, this officer did not tell her until she picks up the phone, because she said she got James Arsenault. So when her and Arsenault finds him, that's when they first find out at 4:49. That works against their position. It doesn't help them, it works against them. So I would maintain specifically, you deny the motion for the continuance.
And we actually to just go back to Article 29.4. We can't argue with the letter of the law.
Okay.
File a motion of our state's first motion for continuance filed. The defense filed a motion on 5/9/2023. Actually, I have it in my 2022. And the state did not oppose that motion. This is our first motion. And based on the letter of the law, 1, 2, and 3, we hit them all. So we cannot have, we need it based on, because he's a material witness. We absolutely need him here. And we can't effectually represent the state of Texas without him. I need him. So that's why it's not for delay. I'm ready besides this officer. I need him.
Okay,
I think I made my point.
okay, I'm looking at 29.04. Now, you basically end your argument on 29.04. You talk about the that he's a material witness. Fine. You have his name, no address. He's an address. He's an officer in the Port Arthur Police Department. I have not heard anything about the due diligence, the diligence which has been used to procure his attendance, and it shall not be considered sufficient diligence to have cause to be issued or to have applied for a subpoena in cases where the law authorized an attachment to issue.
Well, that's why I said we sent a letter. We sent a letter out a couple months ago. I've been looking for him.
A letter, okay.
We've been looking, I've been looking for him for 2 days, since yesterday and today. I've been looking for him even since Monday. I've been looking.
When you say you've been looking for him, you say you sent a letter out. I mean, did you go physically out and look for him?
No, because I work here, so I can't physically go out.
Okay, well, you haven't been looking for him.
I'm looking for him I have investigated. So that's who.
So you had an investigator looking for him.
To look for him.
And that's
Okay.
Looking for him.
Okay, now that's not in your motion.
That's my point.
Okay, I think the way 29.04 basically says it shall be sufficient upon the first motion by the state for a continuance if the same be for the want of a witness to state. The motion shall state the name of the witness and his residence, if known, or that his residence is unknown. That's number one. Number two, the diligence which has been used to procure his attendance, and it shall not be considered sufficient diligence to have cause to be issued or to have applied for a subpoena in cases where the law authorized an attachment to issue. And number three, the testimony of the witness is believed by the applicant to be material for the state. It's a 3-pronged test, not a 2-pronged test. Your motion addresses 2 of the 3. It addresses number 1 and number 3. It does not address number 2. You're addressing it orally, but it here says the motion shall state.
Well, I'm addressing it orally, that we need a motion for continuance, Your Honor, and it's an oral motion for continuance,
Well,
based on the fact that I don't have a material witness.
Yeah,
Okay.
yeah.
So basically you can see something hard and until you judge.
I mean, it just, there was no diligence in the motion. I mean, that's obvious if you just read it. Look at the motion on the face.
And I will say, this is the same type of motion that we file in every case, and it's approved and is granted, so
Well,
I did not know that it had to be modified for this particular situation.
it's not modified. It's the requirements that's required by the law.
And that is fine, it's just, it's been approved without any question, except, when in my.
Maybe it wasn't challenged,
Well, maybe it wasn't. It's just.
but it's being challenged today. Okay, and so, I mean, what we do is, we look at the issues, we look at the rules, we apply the facts to the rules or to the law, and then we conclude. Okay, and so when you applying the facts in this case to the rule, which is 29.04, that this clearly comes under, number 2 is not met. I mean, it's not, that's basically what the law says.
Okay, but it doesn't say that it has to be a written motion followed, so I'm making an oral motion right now for continuance. And I'm telling you why. I'm telling you the due diligence that we performed in the office. I've gotten my investigation.
I thought we had, hold on a minute. Let me look at our, okay.
That's why you're looking at that. When the state council, they should be read. And all what she's arguing, that has been done before. She came here at 9 o'clock in the morning and said, I'm ready to try. And again, he would not have scheduled a conference yesterday. A conference is something that you pay for and schedule in advance.
Okay, let me do this here.
It's not.
I'm looking at the local rules of County Court at Law number 2. Okay. That has been on file since June 19th of 2017. And it says continuances. There is no such animal as an agreed continuance. If either side desires a continuance, prepare a written motion and visit the coordinator and set same for a hearing and then file it with the clerk. If trial on a hearing is imminent, contact the judge for an immediate hearing. If filed by the defendant and the ground is absence of a witness, follow the dictates there, and here is 2906, 2907. If a hearing is not set, you may present, let me see what it says. That's on first motion, 6 first motions for defendant. Subsequent motion for that. Okay, that's for the defense. Election to the jury. Okay. Ex parte presented is not honored. Please have your opponent present. Okay. So in any event, motion for continuance according to our local rules have to be in writing.
And it wasn't writing on.
Okay. I'm just saying that it's in writing, but it doesn't meet the requirements of 29.04 because.
I mean, or argument, why, then we need to continue.
Yeah. Let me do, okay.
You want to take that under advisement, and I can also argue my motion.
Yeah, you're talking about your motion to suppress and your motion in limine. I looked in the
and I got a motion to dismiss as well.
Well,
it's in the system, and the motion to dismiss is in line. Well, do you want me? Well, first motion I asked you to rule upon is my motion for exculpatory information, my Brady motion. I asked the court to grant that as a matter of form, and then I'll go into the rest of my motion.
Hold on, wait, hold on a minute. Hold on a minute. Hold on a
It's
minute.
a Brady motion.
Hold on a minute. Excuse me. See a motion in it. See it.
I have several.
Oh, I'm looking to see, I'm looking in the file. Continuance, was a defense continuance back in May of 2022.
And when you hear my motions, I'll be approved as a matter of fact, this is not their first motion for continuance. And with it not being their first motion of continuance, 2904 would not apply. And if it would not apply,
Okay, hold on a minute.
we need to look at 2905.
Let me do this here. Let's go off the record for a minute. Now, let me ask you, now you're saying that the state has some previous motions for continuance?
Right, and that's a part of my motion.
Well-
I can argue why I say that. But before I get to that motion to dismiss, Judge, I asked you to rule on my.
No, hold on. You said you had a motion to dismiss. When was that filed?
I filed that today.
Oh,
Oh, I think I got it. It's timely whenever I filed it.
okay, well. Okay,
No, it's timely. It's very timely.
well, what I like to see, a motion to dismiss that, I mean, that's on time. We would have to set that, we'll set that for a hearing.
No.
Because one notice hadn't been given to the timely notice for them to prepare.
Okay.
They need time to prepare. I mean, you just can't file a motion and ambush them and,
Well,
you know, we
my
don't work.
motion and eliminate depending upon.
No, you said motion and limit. You was talking about the motion to dismiss.
Correct, but what I'm saying is depending upon how you rule on the motion and eliminate, I won't need the motion to dismiss today. And the motion to eliminate, I can file that the day of trial.
Yeah, I understand that.
So the motion in eliminate,
Hold on a minute. Hold on a minute. When was the motion in limine filed?
that was filed before she filed hers, but I filed mine during the business day of yesterday. She filed her motion. after.
Okay, hold on a minute. Hold on a minute. Because I'm looking
It's
in
the
the,
second motion for.
Okay, hold on a minute. Hold on a minute.
Not for continuance, I'm sorry.
It's a motion in
Second
limine that was filed on the 18th. Hold on.
And look at the time it was filed.
Okay, hold on a minute. Okay, but let's do this here. Before we go, I mean, the court hadn't made a ruling on whether or not this case is going to trial yet. I mean, right now, I'm not gonna address this motion in limine at this time.
Well, Judge, then I would.
So, what I need to do,
I actually deny their motion for continuance, and then we can address my motion and eliminate, as well as I think that regardless of how you decide on their motion for continuance, you can still grant my motion for Brady, my Brady motion. Because the Brady motion is not.
oh, if there's some exculpatory evidence, I mean, you're entitled to get that.
Right, but I would ask the court to actually grant the motion that I actually filed in this.
Well, we've got to read the motion first because we don't know.
It's in.
Okay, let me see that's, where is it? Let me do this. Eliminate. Well, let me do this here.
Because I'm actually just denying the motion and I'm ready to go to trial.
I mean, so the motion in limine, you're just asking for the state or its agents or employees or witnesses not to mention, allude to, or refer to in any manner, any discovery not produced?
Correct. Absolutely.
Without first and approaching the bench,
Correct.
okay? And state,
Gonna follow and abide by the law. So if we haven't produced discovery, we have no problem with approaching the bench before mentioning.
okay,
So is that granted?
you're not objecting to it, right? So,
I'm sorry, we kind of have a ruling that that's granted?
okay, well, hold on a minute. Any September true in the copy. Now, I was just looking at, you said you sent service on the district attorney's office in Orange County?
No, that's a mistake at the top. It's not Orange County, it's served here.
Oh, okay, that's what it says.
No, you're looking at the style of the case and I fixed that.
No, I'm not. No, I'm looking at the certificate of service. That's what I read. And you said that it was on September 19th. The motion was filed on the 18th, right?
But look at the people who were served.
No, yeah, but I'm just saying, okay.
Right, the DA's office got no.
Where's the order? Okay.
Matter of fact, I think
Okay,
I
y'all received notice?
included the DA himself.
I believe that it has been uploaded, but let me. Go back and read.
That was that second motion in limine. Hold on, there's another motion in limine on the
No,
19th?
there was one at previous motion.
Hold on, hold on. This is the third one, hold on. It requested the state agents, employees, and interlude in it. He must have filed it twice.
Correct, same motion twice.
Yeah, he must have filed it. Wait up. Make sure I didn't see in the order. Prosecuted not to mention allude to the above reference to witnesses and mention allude to refer to any manner of discovery, no, including any derivatives of such discovery in the presence of the jury. Daniel Tony Rivera request. Okay. So state, you have any objections?
Yeah, I'm sorry,
I was looking,
still haven't found it.
I got a motion, but I don't see an order.
I can handwrite right quick.
Yeah, I see a motion, I don't see an order.
But I can handwrite one. I just need to.
Okay,
When he filed the motion, the order should have been filed.
right,
Yeah, but
No,
yeah,
when you file a motion, you file the order.
yes, yeah, I don't see an order to
Well,
sign.
the question is, does the court grant a motion?
Yeah.
The order only reflects what happens in the court.
Mhm.
So is the motion granted or not?
Well, they said they wasn't opposed to, yeah, but I just said I don't have an order to sign.
Okay.
So, let me do this here. We have a jury out there.
So why?
Hold on, wait a minute. So you're saying that the motion, I was looking at your motion to dismiss, you said they failed to comply with the court order discovery?
Right, and absolutely. No doubt about it.
Okay, now do you have any like case law to support your position for
Yes.
dismissal?
Absolutely. Well, I would specifically refer to Brady, and I would also specifically refer to this court signs motions to dismiss filed by the states all the time in the interest of justice. And I've seen orders signed with interest of justice. And that's the basis, that's the legal basis that this court has signed motions.
No, okay.
So,
You're saying signing and filing are two different things. The state files the motion, they put what the basis is, the court does not write the basis in the motion.
right, I'll give you-
The court either grant or deny the motion.
Right, and many times it's been granted in the
Yeah.
interest of justice.
Okay, but that's the reason why the state filed the motion but my question to you is, do you have case law to support your position?
Not readily available to me right now, but I would like you to rule on me and that way I can.
I'm not gonna make a rule. I mean, people have to have, you have to have law to support position. This is a court of law, not just arguments.
So that means you would be denying me, and I just want you to deny it on the record that way I can preserve.
I hadn't heard anything to deny. I'm just merely pointing out how courts operate.
Right, and I'm saying in the absence of case law, I'm asking you to rule on my motion
Okay.
so I can preserve it for appeal. In the absence of case law, I'm asking you to make a ruling.
Yeah, okay.
And that's gonna preserve it for appeal.
Yeah, okay.
So,
Well, the court is not going to entertain that motion at this time. Okay. So at this time, what the court has before it is the state's first motion for continuance. Okay. Now, the issue is still going back to hold on a minute. Mr. Adams, you stated that this is not the state's first motion for continuance. Do you have a date, when the state had previously filed?
They haven't filed, they orally requested to continue.
Do you have dates on that?
I got dates.
What,
I can
okay.
put it- and-
Okay. What dates do you have?
Okay. I ask you to take judicial notice of the standard local discovery order that you signed, particularly in this case, and the date that you signed this order was February 22nd, 2023. I got your signature and you signed
Okay,
it
okay.
February 2023. That's the date that you signed this order. In my motion in limine, I said they cannot use what they did not produce in discovery. They agreed to that. So any and all records relating to the breath test and any mention of the breath
Okay.
test, they cannot use it because they did not produce it.
Okay.
Hold on, you asked me a specific date.
No, yeah, the
So-
date that they asked for a continuance, that's what I asked you
That's what
for.
I'm trying to get to. But I'm
I just cut to the chase
All
and
right.
just give me the dates.
The date would be, we were in court on 6/12/23. Look at. your
6/12/23, okay.
Correct.
What
And
else?
if you look on 6/12/23, look at your docket sheet.
Okay,
They did not have this information. You signed an order saying, give me this information in February. We showed up to court in June. So look at your docket sheet.
Okay.
So they requested the continuance.
They
then
did?
Because
Okay.
they didn't have the discovery. They didn't have it. And that's how I said I can prove
Okay.
that this isn't their first request.
okay. That's the date. Okay, we'll
But
look at
your
that.
docket sheet.
Okay, we'll look at that. Hold on.
And the date you signed. this
Okay,
in
quarter being
February.
recessed. Okay, the court is back in session and calls number M329988, case of South State, Texas versus Daniel E. Domina Rivera. Mr. Rivera is present in court with his attorney. Attorney Langston Adams State is present with Assistant District Attorneys, Attorney Eric Porter and Attorney Courtney Davis. The court has pulled this docket sheet in this case, and for the date of June 12th of 2023, was noted on this case was on the trial docket on that day of June 12th, 2023. At that time, the court's note that this case was reset till September 18th, 2023, to complete the blood discovery. That's what's on the docket sheet. Now, what's not on the docket sheet is that it was a state continuance. That's not on here. And I think.
Hey, Your Honor, not to interrupt you, but there was no blood discovery. So I don't know why that's on the docket sheet, but there is no blood discovery.
That's a typo.
Well,
You signed an order for BRIP. I showed you the date that you signed.
Okay, but it was for the discovery.
And when
Right.
we showed up to court on that day,
Right.
it wasn't ready. So it wasn't me who got to go get it. It's them who got to go get it. So who's the one that's asking for the continuance? It's them because they don't have it. I'm not the one to go get this.
Okay, no. What I'm saying, okay. Normally, if you haven't received all of your discovery, then you ask to get the discovery before you can announce ready for trial. You understand what I'm saying? The state already has the stuff. You're the one who needs the discovery so that you can be adequately prepared for trial. So apparently you did not have the discovery, the breadth, the discovery. And so therefore this case was reset or continued. It does not say that the state requested a continuance because they had no need for this. You understand what I'm saying?
I see your point.
Yeah, that's right. So it doesn't say that the state asked for first continuous. And there's nothing in the record to say that this is not the state's first continuous that they actually filed on yesterday.
I see the point you make, but even if we
Okay.
concede that point, as you just said, there's nothing in their motion to show due diligence. And
Right.
the other prong is there's nothing in their motion to show that that witness is material. Show me one thing in that motion that you read where it says, this is the reason why this witness is material. Nothing, zero. So they don't meet that prong.
Well, other thing it says is that the testimony of the witness is believed by the applicant to be material for the state.
What is that?
It doesn't say that they have to state what the materiality is.
Well, how would you know it?
It just says that they believe that it's material to prove their case.
Well, I would say surely they don't have anything on due diligence, none.
Well, I mean, that we go back to due diligence. I mean, that is clearly not in the motion. So, I mean, that's the problem that the court has with the fact that the due diligence is not in this motion.
And I will say, based on Article 29.04, doesn't state that it has to be in writing. So I did orally make that.
Yeah, we have local rules.
Okay, and I understand that.
And the
Okay.
local rules say that any motions for continuous has to be in writing by both parties.
Right, and I have a motion for continuous in writing, but I'm arguing
But-
additional.
But I'm just saying that it's in that part, it's in writing, but it doesn't meet the requirements of 29.04
Correct,
because 29.04 has 3 prongs.
correct. I'm not arguing against that. I'm saying that orally, that I have met the requirements orally of 29. That's my point. Excuse me, that's my point.
Because I think y'all hearing each other, but what at the end of the day, you just told her the oral doesn't matter. It's not in the motion. And she's conceded that it's not in the motion.
Right.
And since she's conceded that it's not in the motion, even though her argument is I've done it
Yeah.
orally, that doesn't matter.
Yeah.
And I think you said that to about 5 times.
Yeah,
So since that doesn't matter, she loses.
yeah.
And I would say, Your Honor, I don't know where is that in the local rules that states that the motion that is. that-
Have you read the local rules?
Yes, but that the motion filed
Okay.
continuous has to meet all the points. I don't see that.
No.
What does local rules say that? Could I see it? Could I
That
see
it has to meet all of the points.
Yeah, I can't argue anything outside of out of what.
Okay.
I need to see that.
Okay, put it like this here.
Mhm.
We cannot take away, we can add, we can give a person more rights, but we can't take away their rights. Okay, let me just preface it like that. And so what you're saying, the local rules here says motions for continuance. It's under chapter 6. Okay, it says, if there is no such animal as an agreed continuance. Okay, 1. If either side desires a continuance, prepare a written motion. Either side. If you desire continuance, prepare a written motion. Okay, and visit the coordinator and set same for hearing, and then file it with the clerk. If trial or hearing is imminent, contact the judge for an immediate hearing. If filed by defendant and the ground is absence of a witness, follow the dictates of 2906 through 2907 CCP on Code of Criminal Procedure. If a hearing is not set, you may be present in chambers or in the courtroom if you desire record. Ex parte presentment is not honored. Please have your opponent present. And basically, that's what it says.
Okay.
Okay. And so when we're talking about a motion for continuance, we're looking at the rules as it applied in 29.04. Actually, under chapter 29 of the Code of Criminal Procedure in 2904 specifically addresses the issue of a first motion by the state for continuance. And then they list 1, 2, 3. What has to be in the motion. And I'm saying in your motion, you have 1 and 3, but you do not have 2. That's the point that I'm, at least that's what I see.
No, I'm not arguing that there was probably not anything stating the due diligence that I did in writing.
In the motion.
Right.
It's not in the motion.
Right, it's not in the motion. I'm not arguing against that. I guess what I'm arguing against is that what excludes me from bringing that up today in court. That's my point. I don't understand what would prevent me from making oral arguments.
One, I guess, is getting the notice. Whatever you put in the motion, actually what you're doing, you're putting the other person on notice.
Mhm.
Okay. When it's not in the motion, that person is not on notice of it. And now you're just bringing it back up to, at the hearing. I'm saying that you can look at it that way. That the defense wasn't on notice as to the due diligence that you have orally brought up after filing the motion.
Right, but all due respect, Your Honor, where's the harm? The defense was aware that I was filing the motion while I was filing the motion because he was unavailable. So I didn't put the due diligence, but where's the harm in not stating what due diligence I performed?
I'm just saying.
I'm sorry not to interrupt you. How am I arguing today cause the defense any more harm? It's no undue surprise. It's no unfair surprise. I'm trying to figure out where you're pulling.
I'm just reading the code. I'm just reading the code.
Right, and I see the
verbatim.
I'm not arguing with the code. I'm arguing with the fact that I can't bring it up orally. That's where I'm not understanding, and where you're pulling that from,
Mm-hmm. Well, I'm just looking at the code and it says that these are the 3 things that are required. And so that's what I was basically looking at. Okay.
So is it denied, Judge?
Well, I'm saying, she did orally bring it up, but I don't know if that's, is there any case law that you have that you can find that says that you can do that?
If you would give me a moment or so that we can get the case law, if there's case
Okay.
to you.
If you have something to support your position. Okay,
Can we have a short recess?
Well, Judge, look at the clock.
yeah, the clock is not now. What I'm gonna do, yeah. We got a jury that's out there. He's been out there since 1:30. I understand that. Now, the nature of this officer's unavailability, well, you said he's material. I mean, I don't know the facts of the case. I don't know what role each witness played in this case. And I'm not asking you for it. But you stated that the person is material in that this is a DWI case, right? And normally on DWI cases, you have at least one arresting officer, right? And that officer would normally, if normally they may call for backup, or they may have a partner riding with them. And one or more of the persons will either do the field sobriety test, the other part, and then they may bring the person to either take blood at the jail or at a medical facility, right? So in this case, I would imagine that this officer that's missing is a witness to either all of that evidence or part of that evidence. Is that correct?
Yes.
Okay. Now, you stated that he's unavailable for the week of the 18th, all 5 days.
And you can't expect us to be in.
No, I'm just saying. You're saying he's unavailable for the week of the 18th.
Correct.
Right. Did he tell you when he was available?
He didn't give, James had to give me a cutoff date, but I'm assuming most training is a week.
Well, I don't, you can find out.
If you're considering.
I mean, that all of that information is part, because normally we pick a jury now on today, and we usually start testimony tomorrow, right? Now, yeah, he may be available tomorrow. I don't know.
Not this, but I'm trying to figure out if he'll be available next week.
Judge, I'm opposing that. Again, I sent him a subpoena, so if you want.
That's true. That's another issue.
And then here's the other issue. Let me just end the case real fast. That just totally ended and get it. All what she's saying now is immaterial because she's already agreed to my motion to eliminate. And the motion to eliminate says you cannot use material that you did not disclose or a derivative of. So hit pause on that. In June, I'm sorry, I take that back. In February, you signed an order saying, as it relates to the breath test, give me the whole file, give me the training, give me the maintenance records, give me the evidence, the improv, give me all of that related to this breath test. That has not been done.
It has never been done?
That has not been done to this day. And that's why I filed the motion and eliminate. And in the motion and eliminate, it says you cannot use anything that you did not produce or derivative thereof. So let's say for the sake of conversation, she brings him to court tomorrow. Even if she brings him to court tomorrow, he can't testify to this because she's already agreed to the motion to eliminate. You've already ruled on it. So if he showed up tomorrow, he cannot testify to it. So at the end of the day, the breath test does not come in. It does not come in. The breath test in this case does not come in. You signed this particular order. The results of that breath test is derivative of this order. So if he walked through the courtroom this very second, he couldn't mention anything about breath test, and they've already agreed.
And Your Honor, I would say anything that I had notice of that the defense wanted the state to produce has been produced. He said that he got it under the first system, not the second. So I don't know if there was. The systems changed and there was one system under the DA's office and there was another system under the DA's office, but if he didn't get it on the second system, I have no control over that. I was not aware because you didn't reach out to me and ask me for anything specific.
Judge, you signed the order.
Okay, let one person speak at a time.
You signed this order. This order is a part of the court's file, and you gave it to the district attorney's office. It's nothing else I got to do. It's almost like they're saying to me, contact me. No, you got a court order and say, give up this information. You did not produce it. We showed up to court in June. You didn't have it in June. Then we because you said it was reset for discovery. So then we show up in September. It's not here in September. I file a motion in limine which says, since you did not produce it, you cannot use it. I'm ready
unless you first approach the bench.
So,
right.
Correct. So at the end of the day, it doesn't make a difference if he walked through the door right now.
Well,
he can't testify to this.
Okay, but there's more than one way to prove intoxication.
Yeah, so I'm ready to go on trial on that. They can't use breath test. If they want to go to trial on standard field sobriety testing, let's go to trial on that. Let's go.
But
it didn't say that we could not use breath test. It said we had to approach. And I have arguments if we have to approach. So
right.
You said that they were automatically excluded.
Right.
We would have to.
Right. That's true. That's true.
So, okay.
Yeah, but I mean, but she would have to deal with it when she, with her position. I mean, I know you're saying that you're trying to argue what she would say or what her position would be, but obviously, she will have to deal with her position.
Well, Judge, I think I would have a very good argument on appeal if you signed a local discovery order saying, give me records relating to a breath test. I put in limine, say, well, you didn't give it to me, and the order was not complied with, therefore you cannot use it in court. Then if the court lets it in the evidence, in spite of the court's own order, I think I got a great basis of appeal. If any bit of breath comes into this case, I think I got an outstanding ground of appeal. And I'm preserving that now.
Yeah, but you're putting the cart before the horse.
So
if you're talking about ifs and buts and all of this, if this and that and the other, we're not even there yet.
What she didn't tell you, I'm sorry. What she didn't tell you, and what I'm telling you is this: the officer Aaron, I think his last name is Reynolds.
Taylor.
Aaron Taylor is the one who took the breath test. That's it. Aaron Taylor, he's the one who did the breath test. So.
Okay.
So we ready to go to trial, Judge? And like I said, you're us waiting for all to happen. It's time to go.
Now you said I was gonna get him some time to find some case law.
Correct.
On that position.
Correct. How much? Are you asking?
It's 3:00 now, man. The jury been here since 1:30, and then all of a sudden, you just filed a motion last night, I guess yesterday evening, asking for a continuation to come to court, knowing that we have a jury coming in at 1:30 today. So we've spent all this time arguing over this motion for continuance that you just filed. And then also Mr. Adams mentioning his motion to dismiss and his motion in limine. Okay. And so I hate to even if I grant, okay, I don't have a position on now, but I would rather see some case law. And at this time, we may have to tell it, come back tomorrow. Okay. We're gonna have to.
Constantly been taken off from work.
I understand, but if he was gonna coming back tomorrow anyway. If I
prolong this case.
Well, if I deny the motion, well, right now. This is part of the trial. This is pre-trial of his case. Okay. He can't control how fast or how slow a pre-trial is gonna go.
Well, if you're gonna give him time to do case law and all that.
You can do case law as well.
No, what I'm saying is that the court did not rule on my motion to dismiss.
I'm not gonna, the order, I'm ruling on the continuance first. That's what was brought before the court. You brought up the fact about a dismissal, but we're not there yet.
So basically, you'll hear my motions if you.
Yeah, court had made a decision. Court wants to make sure that the decision that the court makes will be rooted and grounded in the law. Okay. So I hear your argument. I hear her argument. I'm gonna give both sides an opportunity to provide this court with case law to support their position if you want to do that. If you don't want to do that, that's your choice.
But I guess here's my question. Let's say for the sake of conversation, they can produce you a case today to say, hey, we can, for the first time in court, orally amend our motion. Let's assume that they can find that case. Okay, the outcome hasn't changed.
But we hadn't got there yet. Okay. Well,
That doesn't change it.
I understand what you're saying. I understand what you're saying. I understand what you're saying. But we have to, that's first base. I guess we're gonna use analogy of a baseball game.
Right.
That's the first thing we have to do. Once we get past there, then we'll go to the next step. Okay?
So he's gonna have to come back because if you.
Okay. At this time, what we'll do is take a recess.
Hear that.
Oh. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M333188. The case is styled the state of Texas versus Aaron Justin Horn. Mr. Horn, is that your full name?
Yes, sir.
Mr. Horn, how are you doing?
Doing pretty good.
That's good. Mr. Horn, you're represented in this case by your attorney, Attorney David Grove. Attorney Grove, how are you doing?
Good, Judge, thank you.
The state is represented in this case by Attorney Courtney Davis. Attorney Davis, how are you doing?
Okay, Judge.
State, are you ready?
We're ready, Your Honor.
Defense, are you ready?
Yes, sir.
Ms. Davis, would you please read the information?
Yes, Your Honor. Information in the name and by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Aaron Justin Horn, hereinafter styled the defendant, heretofore on or about September 7th, 2022, did then and there intentionally, knowingly, and recklessly cause bodily injury to another, namely Amber Bradshaw, hereinafter styled the complainant by headbutting victim in the face and kicking the victim in the leg, and at the time of the said assault, complainant was a person with whom the defendant had a dating relationship against the peace and dignity of the state, and it's signed by an assistant criminal district attorney.
Hey, Mr. Horn, how do you plead?
Not guilty.
Not guilty? Okay, state, would you like to make an opening statement?
No, Your Honor, we waive that at this time.
Defense, would you like to make an opening statement?
No, sir, we'll waive that.
Ms. Davis, you may call your first witness.
State calls Amber Bradshaw.
No response.
No response. Ms. Davis, would you like to call another witness?
No, Your Honor, no further witnesses. May the state put a brief, something on the record? Your Honor?
Yes.
Judge, the state has called multiple times the number that Ms. Bradshaw provided to us, and had no response. We've also sent, letters to try to contact her, and also again, no response. At this time, the state rests.
Okay, Mr. Grove?
Your Honor, the defense would make a motion for a constructed verdict of not guilty due to insufficient or no evidence.
Okay, that motion will be granted. Mr. Horn, you are acquitted of your charges. In a few minutes, your attorney will be given a copy of the judgment, acquitting you of these charges. Once you get the copy of that judgment, you'll be free to go, and you have a blessed day. And Mr.
Thank you, Judge.
Grove, you'll be free to go as well, and you have a blessed day.
We're going to see that sign and get you.
Yes, sir.
Okay.
Right, court will be in recess.
Yeah. Two. Or two.
We got everything. We have the, we have the discovery. Okay.
It's the only thing about the community service. You gotta put that on there. Okay?
I don't care, what's.
Next year.
Alright.
And the two boxes at the top, we put it on, I just wanna make sure you understood. You missed, I guess you was going fast. The second one?
He usually just select one.
Oh, you always select one? Oh, wow.
Yeah. You're gonna have to turn that camera.
Are you here in 14?
Or you just go back and forth.
We have annual training and so some of us might
Turn it a little bit.
open up.
That should be good.
Yeah.
She's gonna send it to you. Yeah, yeah.
Yes, I have it.
Okay. I'm gonna go ahead and get started. And I think the court cost is probably already up there. Okay. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number M329-988, case of style of the state of Texas versus Daniel E. Domina Rivera. Mr. Domina Rivera, would you please come forward with your attorney? Mr. Domina Rivera, your full name is Daniel E. Domina Rivera?
Yeah.
Mr. Domina Rivera, would you please raise your right hand? Mr. Domina Rivera, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Mr. Domina Rivera, you may put your hand down. How are you doing, Mr. Rivera? You doing all right? That's good. Now, Mr. Domina Rivera, you are represented in your case by your attorney, Attorney Langston Adams. Attorney Adams, how are you doing?
Doing well.
And Mr. Rivera, how are you doing? You doing all right? And the state is represented in this case by Assistant District Attorney, Attorney Erica Porter. Attorney Porter, how are you doing?
You're doing great, yeah.
Mr. Rivera, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Rivera, it alleges that you, Daniel E. Domina Rivera, on or about May 23rd of 2021, while you were in Jefferson County, Texas, that you committed to Class B misdemeanor offense of driving while intoxicated. Mr. Rivera, do you understand what you've been charged with? And to this charge, Mr. Rivera,
There's a reduction. I don't know if you saw that. He's gonna be playing to reckless driving.
yeah, but I think it may have to be refiled.
So lesser, so.
Yes, I'm going to, I have started typing.
It's not a lesser included offense. It has to be refiled.
I thought it was a lesson.
It is a lesser.
Yeah,
It's a lesser.
but okay. It has to be refiled because of the elements for the reckless driving. It's not like one less of a DWI. It's a lesser included, but it's not one less. So what has to happen is they have to refile it to make it a reckless driving.
Okay, I'll get a refile.
Okay.
And we can, I hate for him to have to come back, but I can get a refile. I said, I'll get in contact with it.
Okay, no problem. So what we'll do, we'll probably, whenever y'all wanna do it, it's gonna be reduced to a reckless driving. That's the agreement?
Correct.
Okay, and you'll refile it as a reckless, and then
But the thing is, I don't want my client to get a new warrant for his arrest.
no. On that day, we can do it all on that same day.
This is the same.
Okay.
You understand?
Gotcha.
So we'll once they file it, they come down, and then we'll be able to do it.
Do it this one suit. Okay,
Mhm.
whatever
Right.
date y'all wanna go on, that's fine.
Okay.
Every day.
Okay, y'all can pick a date because I know Mr. Rivera.
You wanna do it Monday?
Next Monday.
Cause I gotta be in for Stevens anyway, so I can do it Monday and walk over here.
Monday. Okay,
Just come back here Monday at 9 o'clock.
okay, okay. It's good.
They're gonna play.
And all right.
Send it to Monday?
Yeah, y'all gonna have it filed Monday, right?
I mean, I can get it, I just didn't know how quickly I could do it. If you thought, he thought he was gonna be here all week, didn't he, or no? Did he think, did you take out, he took off the whole week?
Well,
I can get him in here maybe Friday if.
how soon? You on Monday, Friday? Okay.
Monday, better.
Monday.
Okay, so it's gonna be reset on Monday. It's gonna be reduced to it's taking care of this DWI case, and it's gonna be a reckless.
Correct.
Okay, that's the agreement. Okay, and let's do this here. Let's put the agreement on record.
Okay.
Okay, now state, what is the offer in this case?
State offers, in consideration of, the defendant pleading no contest, the state has offered 1 year deferred, $500
No,
bond
it
to
gotta be-
reckless, 1 year
It
deferred.
gotta be a $200. You can't
Oh,
apply
yes,
for
200.
records. No higher than $200.
$200 fine, because reckless is $200 is the max. 60 hours community service and court costs.
Okay, Mr. Adams, is that your agreement?
Yes, sir.
Okay, is that your agreement also?
Yes, sir.
That's your agreement, okay. So, this case is gonna be reduced to a reckless, and, we'll reconvene on the plea of this case on Monday.
Thank
So you
you.
here at 9 o'clock?
All right, y'all have a blessed day.
Thank you.
Thank you.
Okay, you're welcome. Okay, now, well, let me get talk to the jury first.